Now I can invite Hayley up to be the presenter. Hayley Boxall is here to present. Hayley from the ANU.
I get it now. All right. Is there any chance I can move? Can I have a microphone? I can take your microphone. I tend to like to move around. Okay, guys, so this is a bit of a pivot. We're going to talk about some strengths-based stuff, some hope in terms of some interventions that could actually potentially help, not necessarily in preventing homicide or necessarily even recidivism, but in terms of preventing, I guess, re-traumatisation of victim survivors and addressing their justice needs. So in the last 10 years, there's been a lot of increased interest in restorative justice processes for domestic, family and sexual violence matters in Australia. And that really started in earnest in about 2016 when the Royal Commission in Victoria on Family Violence made an explicit recommendation for Victorian government to consider the implementation of a pilot for RJ processes for these types of matters. And since then, a lot of the jurisdictions around Australia have been at various stages of implementing their own pilots or expanding the remit of their existing restorative justice schemes to include domestic and family and sexual violence, with the ACT probably being the most furthest along that journey. So there's actually a pretty compelling evidence base to support this work. So there's a lot of empirical evidence that shows that traditional criminal legal responses to domestic and family and sexual violence does not meet the justice needs of most victim survivors. At their worst, they can be re-traumatising, but certainly a lot of advocates and research has shown experiences of minimisation, denial, victim blaming, interrogation being experienced as distressing are very, very common experiences amongst victim survivors. There is also that question, which I think is really beautifully put by Auntie Yvonne this morning, of is the criminal legal system at its core the best base to address the justice needs of certain communities, including victim survivors of domestic and family and sexual violence? Because certainly in response to this evidence base, there's been a lot of policy investment in trying to improve criminal legal system responses. So expanding the definition of what we mean by domestic and family and sexual violence, changing evidentiary kind of remits and thresholds for what can be presented in court, as well as those procedural aspects of how we do the criminal legal kind of process in terms of interrogation and those kinds of things. And all of those reforms are to the betterment of and improvement of the experiences of victim survivors who want a criminal legal system response, who see that as part of their recovery journey and as meeting their justice needs. But the uncomfortable truth is that a lot of victim survivors will never want to have contact with the criminal legal system. They will not want to criminalise the perpetrator for a range of different reasons, and also that the criminal legal system will not be perceived as safe. No matter how many reforms we put into place, there are communities who will not willingly and with open arms go into that space. So there is obviously a good evidence base around why we need something different for victim survivors. On the other side of the empirical coin, we have fairly good evidence now from systematic reviews from the AIC, where I used to work for 50,000 years, as well as the Campbell collaboration, that traditional criminal legal system responses aren't really effective in stopping recidivism amongst perpetrators as well. And that's for things like arrest, incarceration, protection orders. So obviously we're not doing very well on the perpetrator side of thing either. So then there's this big question, well, okay, so what do we do to improve what we're doing? So the evidence for why we're considering alternative justice mechanisms like RJ is pretty well developed, but actually the evidence supporting the use of RJ specifically is pretty limited. A 2018 systematic review that tried to look at what the evidence says about the efficacy of these processes was a page and a half saying there's no evidence, we need more evidence. And so that's where we came in. So in 2018, the ACT expanded their pre-existing restorative justice scheme to include domestic, family and sexual violence matters. So the ACT is actually quite unique in the Australian landscape in that they've been doing RJ for yonks. They were actually the site for the reintegrative shaming experiments, which was led by John Braithwaite in 1995, a bit of the ground zero in terms of RJ in Australia. It's been enshrined in legislation since 2004, which has provided guidance around referral mechanisms as well as definitions of different types of offences and eligibility criteria, and was expanded in 2016 and then again in 2018. So because obviously a lot of policy interest in RJ for DFSV, while I was at the Australian Institute of Criminology, we decided to fund an evaluation study of the program. So we were around for a very long time harassing the Restorative Justice Unit for this evaluation, and that's because COVID happened in the middle of it, which had significant implications for their operations, which meant that we couldn't get the sample size necessary to do the analysis we wanted to do. So that's just why we were around for so long. But we did a process and an impact evaluation, an outcomes evaluation involving the analysis of both qualitative and quantitative data. There's a big report that describes all of the things that we did. I'm not going to bore you with it, but I can take questions. So with the time that I have with you, I want to kind of go over some of the key findings from the process and the outcomes evaluation. I can't go over everything. Again, there's a massive report. Happy to take things on notice and questions. All right, so one of the biggest questions we used to get asked by jurisdictions who wanted to kind of get a bit of breadcrumbs about how the restorative justice scheme was going in the ACT was, what does it look like? Because it's all well and good for us to kind of say, RJ for DFSV, hurrah, but we also recognise that DFSV provides or has unique dimensions associated with it that may make RJ more problematic. So how do you adapt the RJ process to meet the needs of this new population? So one of the things that they did is that they implemented a co-convener model. So usually with the restorative justice scheme, they would have one facilitator per matter, but because they recognised that there was an increased risk of collusion, as well as not really identifying what was really going on within the relationship, and also the higher intense needs of the person harmed, the victim survivor, and the person responsible, the perpetrator, they used a co-convener model. So there was also a concern about people being manipulated or coerced to participate in the program, and so they had a very victim-centred approach where the person harmed was first approached and asked if they wanted to participate, and if they didn't want to participate, then it didn't go any further, regardless of what the person responsible wanted to do. Also, typically with RJ, it's very much focused on what happened here with this incident and looking into the future of how do we address harm. But they changed the way they operated in terms of they really took the time to understand the patterns of abuse within the relationship, to understand the dynamics, as well as the presence of coercion and coercive control. And because of that, they were actually able to identify a couple of cases where a victim survivor had been misidentified as a primary perpetrator and then kick those cases out, which I thought was just a nice little kind of aside. And finally, victim survivor safety and control. There was continuous risk assessment. The ACT policing, they use a risk assessment tool called the FV-RAT. RJU, the Restorative Justice Unit, adapted this and used it for their own purposes to identify high-risk cases that they didn't feel comfortable holding kind of responsibility for. And this risk assessment was ongoing and matters could be kicked out of the program at any point in time. So let's look at what actually was referred to the program. So 162 matters were referred to the Restorative Justice Unit over the 4-year observation period. So for the persons harmed and persons responsible, there was very clearly a divide where persons responsible were primarily male, persons harmed were female. The main referrers were the Magistrates Court, ACT Policing and the Children's Court. And that's quite important because who referred the matter tells you what stage of the criminal legal system these matters were being referred. So if it was referred by ACT Policing, it means it was pre-charge. So it was operating in a diversionary kind of sense of trying to kind of filter out first-time offenders. Whereas the Magistrate Court and the Children's Court, it was post-charge, pre-sentence. So while they were going through the court process, they were also going through the RJ process. Matters being referred post-sentence, so for example, at a parole board meeting, identifying that this person's returning to the community, you might want to do an RJ process, very, very rare. Also, community-based referrals from DFSV services was very, very rare as well, and I'll come back to that. So the types of matters that were being referred was primarily family violence, followed by intimate partner violence, and then very rarely sexual violence. So when you actually dig into the data a little bit more, it again kind of shows you some really important, I guess, points about what matters were being, considered suitable by referring agencies. So the most common by far was child-to-parent violence, so adolescent violence in the home, primarily towards siblings and parents, primarily female carers, followed by intimate partner violence with a current partner. So this kind of tells us again that potentially one of the main motivators for people accepting referrals was around relationship repair, because these are ongoing relationships between a child and their parent who they are probably cohabiting with, or they want to return to the home. They want to have an ongoing relationship with them. And again, that's a similar circumstance with intimate partner violence and a current partner. So if they've been referred to the program and they want to do it, a lot of it is about relationship repair. And that's something that definitely came through as part of the interviews that we did as well. Right, so there's a whole bunch of information we provide in the report about stakeholder views of the program, and Siobhan Lawler, who worked with me on this research project and led it, has actually written a separate kind of paper about stakeholder views, which I encourage you guys to have a look at. But I wanted to pick up on one of the tensions that we pulled out of the stakeholder interviews, because I think it's conceptually very interesting, which satisfies the kind of theoretical wanker in me, but also has significant practice implications when we think about gatekeeping in terms of who is suitable for this type of program. So one of the eligibility criteria for the Restorative Justice Scheme is that the person responsible takes responsibility for what they've done. In the post-charge context, that usually means that they've pled guilty to the offence. In the pre-charge context, it's a bit more nebulous. They have to have kind of shown something like remorse or a willingness to talk about what they've done, minimising of what they've kind of done. It's a bit unclear what that kind of looks like. But there was this real kind of question mark that emerged through the evaluation, which was, is taking responsibility an eligibility criteria, or is it an outcome of the program? Because the RJ practitioners very much viewed themselves as part of the work that they were doing was getting the person responsible ready to take responsibility for what they had done as part of the conference. And so as you kind of see with the quotes here, I'm not here to judge people. My job is to work with you to get you to a place where you can acknowledge and also hear the impact you've caused and be able to respond to that. Meanwhile, the referring agencies very much talked about who was eligible for the program and talked about who deserved restorative justice. If you had offended previously, you weren't suitable. If you had minimised some aspect of the crime, you weren't suitable. So there was this kind of gatekeeping effect, which was which was altruistic in nature, because they didn't want to expose the victim survivor to someone who was denying, minimising, blaming them for what had happened. But then something else kind of interestingly kind of emerged, which was, well, what are the needs of the victim survivor? What are they trying to get out of this process? And a lot of the victim survivors that I spoke to said, even if he had apologised, I wouldn't have believed him. I didn't need him to take responsibility to get what I needed out of this process. So then there's this question mark of, well, okay, if the victim survivor says, I don't need him to be held responsible to get what I need out of the justice process, are we creating unhelpful barriers to victim survivors accessing this scheme because we have in our mind who the perfect perpetrator is? And as we kind of talked about with the practitioners very much said, look, if you're looking for someone who's mea culpa, I am so sorry, they would again think that they're disingenuous and they're doing it for the wrong reasons anyway. So there is this big question mark for other services who are looking to do RJ in this space. Is taking responsibility an eligibility criteria, or is it something that you're working towards as part of the practice? So in terms of conferences, there was a very low conversion rate, so about 15%. And the kind of attrition of where matters kind of fell out of the system was at that initial consent point. So the vast majority of matters that didn't proceed stopped at the point of the RJU contacting the person harmed and saying, do you want to take part? A lot of them just did it through passive means of just not answering the phone. Sometimes they picked up the phone and said, look, I'm just not interested, or I don't think that this would work for me, or I want to move on, I don't want to revisit this. But for the vast majority of cases, so about 95% of matters that the consent was granted and they were deemed to be suitable, they did proceed to conference. So again, what did those matters look like? Half of them were child-to-parent violence, followed by intimate partner violence involving a current partner, and then sibling-to-sibling violence. And when I spoke to the victim survivors, it was very much about they wanted relationship repair because they wanted the relationship to continue, they just wanted the violence to stop. 92% of the restorative justice processes were delivered in person, and agreement. So not all RJ processes or conferences end with an agreement, which is a written document kind of outlining the ways in which the person responsible is going to make amends to the person harmed and the community. But it did occur in about 2/3 of matters referred to, and that proceeded to conference through the RJU. So 100% of the persons responsible said the agreement was fair. This decreased to 78% of persons harmed who said the agreement was fair. And I think it's really interesting when you look at satisfaction with outcomes. So the post-conference survey was administered approximately about 6 to 12 weeks after the conference. And it wasn't administered by an RJ facilitator, it was third-party kind of volunteers. And at time of being administered the survey, they were asked, how did you feel at time of the conference about the outcomes? And then they said, how do you feel about it now? And the person responsible was really satisfied both times, but the person harmed were less likely to say that they were still satisfied with the outcome when asked, how are you feeling about it now? And when we interrogated this kind of dip in satisfaction with the outcomes, it was about the person responsible hadn't fulfilled their requirements as part of the agreement, which was very much an issue with the system because the Restorative Justice Unit has no remit to do anything with the parties once the conference is done. They can do an agreement, but there's no kind of monitoring of whether or not the person responsible is doing what they said they would do. And so that dip in satisfaction with the outcomes is about, well, no one held them to account. And that's not the Restorative Justice Unit's, their remit. They don't have the funding to do that kind of follow-up work. So I guess that's one of those kind of system questions of, well, who's holding those people after the conference? This can't be seen as a silver bullet. So one of the things that we spoke about with victim survivors and as part of the post-conference survey was about how the conference kind of went for the victim survivors. Very high rates of feeling like they felt that feeling that they were able to say what they wanted to say, that they gave them a chance to explain how they were affected, and that they felt that they were being treated with respect. So I just want to blitz through very quickly victim survivor stuff. In terms of the outcomes we observed, victim survivor recovery was a really, really big one. In particular, victim survivors talked about being able to draw a line in the sand underneath what had happened to them, that they felt a sense of catharsis because they were able to really just in their own words and in their own way talk about what had happened to them. Some of them also spoke about being able to ask questions of the person responsible. Why me? You said you loved me. Why did you do this to me? And even if the answers that they got wasn't what they wanted, they still felt that they had a better understanding of what they had experienced, which helped them on their recovery journey. So many of them did talk about this feeling of, I can move on now. I feel like I left everything that I needed to on the dance floor and now I can move on with my life. And then again, on relationship repair, for those persons harmed and persons responsible that we spoke to who said that relationship repair was really important for them, that definitely came through. They talked about how they were finally able to have a facilitated discussion where everyone was able to actually talk to each other without being interrupted, without being spoken over the top of. They were given a supported space to really talk about what was going on. And it didn't, and they specifically said it wasn't just about the incident, it was about everything that came before. and it was intergenerational. And so there were some family violence matters where they had multiple generations sitting around the table really airing everything that had happened to them. And again, sense of catharsis, ability to move on, and ability to move forward. And then finally, I won't do the identity making, even though I love it because I loved assistance. Let's talk about the administrative data. So we did analyse ACT policing data and ACT corrective services data for a sample of persons responsible who participated in the Restorative Justice Unit, not necessarily going to conference. So about 150 we were able to get ACT policing records for. And then we had a comparison group which was balanced using entropy balancing. I've never used entropy balancing, so I can't really speak to it. It's apparently better than propensity score matching. Cool. Anyway, so the 3 outcomes we looked at was prevalence of reoffending, frequency of reoffending, and time to first reoffence. And what we found was that for adults, it reduced the frequency of reoffending in the 12-month post-intervention period. There was no difference for any other category, which means that it's not criminogenic, it's not a soft-on-crime approach, it's no better or worse in terms of predicting recidivism for people going through these types of programs. But when you balance that against the significant impacts for victim survivors in terms of truth-telling, catharsis, feeling heard, feeling like they're able to kind of move on, I think this is one of those programs where, again, it's a social justice imperative. If there's victim survivors who want to do this, who want to invest in relationship repair, we kind of have to meet them where they're at. So I have some key messages, but I won't bother going through them. Thanks, guys.
Great, thanks Hayley. It's so interesting. I know that there are some questions already in Slido, but is there anyone in the room who would like to ask some questions? So one of the questions that we had, Hayley, was you say this is as a diversion, but can this sit alongside your standard criminal justice response, which I think you sort of already discussed a little bit here, and also how important is it to be in legislation, like in the ACT?
So yes, if a matter is referred pre-charge, then it can be a diversionary option. But that doesn't mean that at the end of the conference, charges won't subsequently be laid. But if it is post-charge, then there's this expectation that the court process will be adjourned until the conference has been finalised, because then the magistrate gets a very one-sentence report from the Restorative Justice Unit to say, yes, they've participated and that kind of thing. So it's not necessarily supposed to influence sentencing decisions, but it kind of does. It's a very weird kind of wibbly-wobbly space. What was the second part of the question? Oh, in legislation. It's really been very helpful, I think, in terms of facilitating referrals, because within the legislation, there's an expectation that it's more of an opt-out process, that you almost have to demonstrate why you haven't referred a matter to restorative justice. And that mechanism has been very helpful for kind of bringing some of the referring agencies on board in terms of, have you considered RJ for this matter? If not, why not? Because the Restorative Justice Unit very much has this attitude of send them all our way and we'll sort through them, to kind of see whether or not we think RJ is suitable in these matters, because they do have genuine concerns around gatekeeping around this as well. But I think that there's a bit of a balancing act there.
There is a question. Suzanne?
Hayley, can you talk a little bit about the plans that were put in place? What sort of things were in them? What were the requirements? And also, if it's not the RJ coordinators, who should be held accountable for making sure that those plans are delivered?
So for the agreements, a lot of it was around engagement, voluntary engagement in counselling / therapy / there's a program in the ACT called Everyman, which is very much about positive masculinities and those kinds of things. So it could be some kind of education. It could also be some kind of community-based kind of reparation work, so having to volunteer somewhere. In family violence cases, it could be things like an agreement that they won't use drugs and alcohol in the home, that they won't smoke at home. So it very much kind of depended on the flavour of the conference and what the parties all kind of agreed to. And there was the second part of your question, no, I've forgotten. Oh, yeah, meet the agreements. So that's a really good question. Ideally, when it's a child-to-parent family violence matters, a lot of these kids are already being case managed by juvenile justice or have some kind of case manager. And potentially that could be part of their role, but that would require some actual kind of coordination work, which the Restorative Justice Unit is very, very good at, but then that passes an impost on to the case managers to have to manage this as well. My feeling is that restorative justice schemes should just actually get more money to be able to kind of do some of that follow-up work, because speaking to the RJU, they want to do the follow-up work because they recognise that, I mean, something I wasn't able to talk about is that these matters took a very long time to get to conference. So 12 months was the average. And so they had developed these relationships, very strong, supportive, safe relationships with these family members and these victim survivors and perpetrators. And so they wanted to kind of continue to leverage that because they recognised that the conference was only a few hours in a day, but there was all the stuff afterwards. So that just means increasing funding for those kind of models because they want to do it, but also they've got the relationships to do it.
There's probably time for one more question from the floor, if anyone's got another question. Well, there is a question on Slido as well. So the question is, do you see that the RJ positive outcome, so being heard, the cathartic response for the victim survivor, do you see there's been something that could be translated into a DV specialist court, the same sort of outcomes that we're seeing for RJ?
I think so, yes, because I mean the evaluations that I've seen from, say, the Southport Court and those kinds of things have been similarly having someone listen to their story, because the adversarial criminal legal system kind of has a very specific way of trying to get information from people, and that's not necessarily conducive to narrative and to storytelling, which we know from narrative therapy and from desistance research and all of those kinds of things. The stories that people tell matter in terms of it helps them to understand what's happened to them and they want to get their truth across. So I think those courts are better placed to do that because they have a very different kind of therapeutic jurisprudence kind of model. And I've certainly seen some emerging evidence to say that there are some victim survivors who value that.
Let's thank Hayley once again. Thank you.